Mr. Ratner, Ms. Ratner.
Mr. Chief Justice, and may it please the court. If you read the Helms-Burton Act from front to back, you'll have one clear takeaway, and it's the one already mentioned this morning, that the 1996 Congress wanted to put crushing diplomatic and economic pressure on the Cuban government. That includes by abrogating the sovereign immunity of Cuban instrumentalities in claims brought under Title III of that act. Now, there's admittedly a high bar for abrogation, but this court has said again and again that Congress doesn't need to use magic words to get there. It just needs to make its intent clear through what Kurtz called the sum total of its work. And it did that here. Let me start with the most important piece, Section 6082A. Congress created a cause of action and expressly applied that cause of action to foreign instrumentalities. That's a standard route to abrogation that this court has recognized in Kurtz, Kimmel, Hibbs, and Financial Oversight and Management Board. Then Congress did three things to confirm that that was its intent. First, we know with absolute certainty that it wanted claims and judgments against Cuban instrumentalities because it repeatedly discusses them, including at 6082A7, C2, and D. That was up for debate in Kimmel and Kurtz. It's not up for debate here. Second, Congress emphasized that it wanted fully effective remedies in US courts, including against governments. That's 60818 and 11. And third, at the same time it authorized suits against Cuban instrumentalities, Congress also codified an incredibly restrictive embargo cutting off commerce between the United States and Cuba. That combination makes no sense if Congress had intended to rely on FSIA exceptions that depend on commercial activity. I welcome the court's questions.
Are we to treat the assertion of sovereignty the same here as we did in Kurtz?
Well, Justice Thomas, to the extent you mean, is there a different test for foreign sovereigns or other kinds of sovereigns? We have not argued for a lower test. I think arguably the sovereign immunity asserted in suits involving states and the federal government may be on even stronger footing than the sovereign immunity of foreign governments, because when it comes to foreign governments, that's entirely a matter of comedy and grace. But our point is simply that foreign governments shouldn't be better off than all of the other types of sovereigns, states, the federal government, Indian tribes, and territories in the case that...
If we accept your argument, what would the interaction of Title III and FSIA look like?
So there are effectively two ways to harmonize those two statutes here. One is the way that we're advancing, which is the FSIA is a general rule, and the Helms-Burton Act is an additional specific abrogation. The other way of harmonizing is what respondents have said, which is the Helms-Burton Act provides the cause of action, and the FSIA provides any abrogation of immunity. And our point is simply, it is not plausible to believe that Congress intended the latter rather than the former. And we know that for several reasons. I think the fact that it simultaneously enacted the embargo is a pretty glaring one. The court often says Congress doesn't enact meaningless statutes. And the notion that it would circulate these claims over to a separate immunity regime that depends on commercial activity with the United States, while simultaneously banning commercial activity with the United States, is a pretty glaring neon sign.